This week's episode of Art of Law, Law of Art, is brought to you by Avatar Computing. Avatar Computing is a full-spectrum IT shop providing help desk services all the way up to program management. Find them on the web at www.avatar-computing.com/commercial. All right, hi everybody. This is Matthew Foster, and this is the third now episode of Art of Law and Law of Art, which we never changed up the name, but it works, right?
Absolutely.
And I'm joined again by Richard Alves. How you doing, Rich?
Good. How you doing, Matt?
Not too bad. And today is our first attempt to do it over Skype, which actually is kind of the thing with this podcast channel anyway. So this will probably be the norm in general. But today, to break away from last time, so the first time we talked about like all the different ways that people can protect things in general in the law. The last time we talked, we really kind of talked mostly about copyright as a vehicle. And then today I figure we'd talk a little bit more about trademarks and how that's different.
Right. Sounds good.
So if I'm which I am, I'm an artist. Copyright to me is the thing that we normally talk about the most as a normal thing. What would we do in the case of a trademark? Like who does a trademark make sense for?
Mm-hmm. Right, sure. I mean, I would agree with you. I think that for the artistic community in general, copyright is certainly the one discipline within IP law that they're most concerned with. Now, trademark law is certainly another discipline that's important to anybody that's doing business. And really, I guess to answer your question, trademark law would be essential, critical to anybody that is in any way doing business in commerce, whether or not they are a retail shop or whether or not they are providing services. Trademark law is something that is absolutely critical to them and to make sure that they have protection in.
So it's definitely it's not some, well, so do you do it ahead of the time of the product or do you do it after the fact or?
Well, it's actually, of course, like so many things in law, it's a little bit of both. And the reason that it's a little bit of both is actually it's kind of complicated. There are several reasons why it's a little bit of both. One reason why it's a little bit of both is that you can do it ahead of time if you seek federal registration, and I'm sure that we'll get into more of the distinction between federal registration and common law protection. But federal registration does almost allow you to reserve a particular mark in advance by filing what's known as an intent to use application. And basically what you do with that is the applicant is telling the government that they have a bona fide intention to use that trademark in commerce, and the government will kind of take them at face value and say, that's fine, we'll let you kind of step in line in front of everybody else, and you have rights to that, but those rights don't mature until the point where you actually start using it in commerce. So it's really, the linchpin is use in commerce, but you can effectively reserve the right to that name in advance.
But how long can you reserve? I mean, is there what you just said brought to mind to me about three different questions. So reserving it, how long are you allowed to reserve it for?
Mm-hmm. That is kind of going to depend upon how long it takes to prosecute the application in front of the Patent and Trademark Office. But generally speaking, it's probably about, say, 12 to 18 months from the time that you file an application until the time that you have that application finally resolved by the trademark attorney. And I'm sorry, go ahead.
Oh, no, well, I was just going to say, so is that something you would do like as a startup? Like, okay, I want to start this business. That's where you would reserve it in a way where, okay, we're wishing to use this, but we're just starting up and it's going to take us some months to do it. You can't just reserve it so that someday hopefully you can use it.
That's right. No, you have to have a bona fide intention to use that in commerce. And what I was referring to before as far as the application being finally resolved by the trademark attorney, what will happen if you file an intent to use application is that they will publish your mark for opposition. So anybody that thinks they might be harmed by your using the mark has a chance to oppose it. And after that, after it is published for opposition and is out there for 30 days, if nobody opposes it, you'll be granted a notice of allowance. And what you have to do at that point is continue through the prosecution process, and say that 3 times fast.
Yeah, right.
And
that's why no one wants to prosecute.
Exactly. And what would happen is you have 6 months to actually file a specimen of use. Now, if you don't file a specimen of use within 6 months, which is basically just proof that you have actually started using the mark,
okay,
you have up to 2.5 years to continue to file requests for extension of time, and those are done in 6-month intervals. So you do it on day 1 after the mark has been published, you get 6 months. 5 months and 25 days after that, if you're still not using it, you file another request for an extension. The first one you get for free, but after that you have to pay for each request for an extension. But it does buy you an extra 6 months, so you get to essentially do that until the point where you have gone out, basically almost 3 years at that point, and then you either have to use it or be done with it.
So when you say, and I'm gonna back you up because all of this is very dense information, So I'm gonna unpack it a little bit.
All right.
Is that so I apply for a trademark, and for listeners of this, I'm actually in the middle of doing this, and you are helping me. So
that's right.
I can relate to what you're saying very much because we've kind of gone through some of these pieces already.
Mm-hmm.
But so I apply for a trademark.
Right.
And then you said that there's a period of time where it gets published and then people can, what's the right term?
Oppose your use of the mark.
Right. So they can sit there and say, hey, wait a minute, I have a candy bar named that or whatever.
Right.
And it's not fair that you can use that. How do they... Are they emailed it because they have a similar name, or do they have to know to go look that I published it?
They actually have to know to go look that the mark has been published, and that's kind of what's known as policing the mark. Once a trademark owner starts using a mark, they have an affirmative obligation to police their mark, to make sure that nobody else is using a confusingly similar mark. And the reason why is that trademark law kind of really does a lot in the way of consumer protection, and the burden is kind of put on the owner of that trademark to make sure that nobody else is using a confusingly similar mark because it could harm consumers in the marketplace.
Right.
So they would need to know to go look for the mark, and where they would do that would be in the official Gazette, and that's published online by the Patent and Trademark Office once a week.
So is that something that, so let's say, futuristically, I have the trademark done and delivered as my trademark.
Right.
I need to put that on my calendar that every so often I need to go check to see if someone is using my trademark?
Well, what you would probably want to do, probably the best thing to do is to check that official Gazette pretty much, weekly or every couple of weeks or minimum like once a month or so. And the reason being is because not only do you want to be sure that that you're doing an adequate job of policing your mark, but you want to actually protect that because that's now your intellectual property. That's now your asset.
Right.
And you want to be sure that nobody else is diminishing the quality of that asset.
Right. Okay. And now, do they publish it regardless? So I have mine assigned to me, and I'm trying to phrase my question to get across what I'm getting at here. So I have my trademark, and it's great.
Right. Mm-hmm.
And you don't know me, and you have a similar trademark that's going out under the same name, right?
Right.
And you go to the Patent and Trade Office and you apply for one. Will they simply put it in automatically and let the industry police their own marks, or if they see that it's already contradictory to something that's in there, will they shuffle it off on their own? Or
yep, absolutely. That's one of the benefits of having a federal trademark registration is that you get the Patent and Trademark Office there to help you protect your mark in certain ways. And what they do is the first thing that an examining attorney will do when they get that application is do a search of their records. And if anybody else has a federal registration that they deem to be confusingly similar to yours as the applicant, they will refuse your application under a particular section of the Trademark Act. It's Section 2D of the Trademark Act, and what they are citing at that point is that there is that your mark is likely to cause confusion with another mark that has already been registered. So that is one of certainly the most significant benefits of having federal protection of your mark.
So, okay, so that makes it more understandable to me as far as someone applying, is that it's not just out for the wolves to attack you once you put it in there. There
Right.
is some, hey, there's already such a thing as a Twinkie. We're not going to let this go forward.
Right, right.
Now, with that said, I'm assuming there's anomalies in there where people have similar names, but it's okay.
Right, exactly. And that's you're right on. I mean, it's perfectly permissible to have even the same exact name if you're using that name on something that is unrelated to somebody else's use. And the reason being that, like we'd said before, trademarks really are used to identify and distinguish your particular products or services from those of somebody else. And the reason that they exist really is in part to further this consumer protection idea. And it has been determined essentially that if the same exact mark is used on something that is unrelated, consumers just simply aren't going to assume that those two products are in any way related. I'll give you a good example. It's a famous case on Lexus, Lexis, the legal software company,
Yeah.
and Lexus, Lexus, the car manufacturer. The names are almost identical. They're certainly phonetically equivalent, but
sorry, not to interrupt you, but phonetically equivalent counts.
Yes, oh, absolutely, absolutely.
So,
Yeah,
so even if I spell something differently, if it sounds the same as Ford,
right.
it's still wrong. It's still a bad idea.
Exactly. If you came in and tried to register the mark Ford, Phord,
Right.
for automobiles, I guarantee you would be refused registration.
Almost instantly, right?
Almost instantly.
Yeah. So I'm sorry, not to cut you off.
An attorney, but
So, well, back to the Lexus thing. I didn't mean to cut you off, but that's an interesting point.
But it's basically the same exact point there, which is that in that case, it turned on the fact that nobody would assume that a car manufacturer is also out there providing a legal research service. So they let the two marks coexist.
And do the companies have to agree to that also?
Well, in that particular case, it was litigated, and they did not need to agree to it, but the courts just basically decided for them.
So when I'm sitting down, well, you see this on the web a lot now, and sometimes I wonder if it's just branding or if it's actually trademarking. When you have like Artio, which is a good example of what I'm thinking of, where they intentionally spell something strange, even though it sounds like a normal word.
Right.
And Artio, not that Artio is a real word, but obviously you would make the logical jump to radio. But I'm trying to think of something else like Flickr. Mm-hmm. And Flickr, doesn't have an E in there, so it's just Flickr with just an R at the end.
Right.
And I always assumed, just being a casual observer, that that there was a trademark issue and they had to change the name, or that they couldn't license that name because someone else owned it. Mm-hmm. But what you're saying is really just the fact that it sounds like Flickr should be enough to be a problem.
Yep, that is absolutely enough to be a problem. There's no question about it. It's the way that the trademark attorney will review that at the Patent and Trademark Office is they will look at the similarity of the mark in sound, appearance, and meaning. Huh. And those are the three linchpins of what they will look at when they're looking to try to establish similarity between one mark and the other. And there's a whole line of cases that basically says that the mark is used quite often as a spoken term, and therefore, if somebody were to refer to Flickr, the Flikr or CKR, whatever it might be, the Flickr without the E, basically.
Right.
They would never be spelling it out the way that I just was. They would simply say Flickr. And that's why there's this whole line of cases that have established that the fact that you're spelling something a little bit different, but yet they are phonetically equivalent, doesn't make a difference. It doesn't allow you to bypass trademark laws and to essentially infringe somebody else's trademark.
That's interesting. So really, some of these choices that you see on the web, and now that we're talking about it, a couple of them are coming to mind to me. Some of them are probably just branding, just to be clever.
I think that's entirely the case. Yes. Yep. That's entirely the case.
One of my favorite ones is a site called, and actually they just got bought by AOL, I believe, but gdgt.com, and of course everybody calls it gadget.com.
Oh, okay. Yeah.
But it's obviously much shorter to write, and it's a little trendier looking and all that stuff.
Right.
But again, one of those cases where when I first saw that, I was like, oh, they must be skirting around some kind of copyright or a trademarking issue.
Right. Yeah.
And now I'm thinking, no, they just did it to try and sound cool.
No, I think you're right. I think that's exactly what they did in that case.
That's interesting.
Now, in particular, because I guess gadget might not be a great example, but that's we talked about the similarities of the mark, and that's one of the considerations. And that is with respect to likelihood of confusion. But if you go back to what we were saying before, which is that a trademark needs to be something that can identify and distinguish your services in the marketplace or your goods in the marketplace, what that also means is that it can't be something that is merely descriptive. In other words, there's a sliding scale, and not all trademarks are created equal. And if you have something that is merely descriptive, that's another analysis that the trademark attorney at the PTO is going to go through. And if they think that your mark is descriptive, people are not going to view that as an identifier of source, then they're going to refuse your registration under a different section of the Trademark Act. That's Section 2E1 of the Trademark Act.
So,
and I'm sorry, go ahead.
Oh, so what would be an example of something that's just descriptive, like?
Mm-hmm. Yep, that's exactly where I was going with gadget. I think gadget you'd probably get away with, but if you were trying to use the mark for, say, Tasty Bread for a bread company, well, that's merely descriptive. I mean, all you're doing is saying, hey, this is tasty bread that we're selling. So therefore, somebody under a trademark attorney would review it and take a look at it and say, it's under Section 2E1 of the Act, that is merely descriptive. It's not going to function as a trademark. It's not going to be something that people will identify a particular source for unless they are able to establish distinctiveness in it. And we can get into that in a second. But the point of that being that there is this spectrum of distinctiveness is what it's referred to as. And on the one end, you have the really, really strong marks. On the other end, you have the generic marks, and merely descriptive is certainly further towards the weaker side and the generic side. For example, if we were looking to sell laptops, we could not name our company, laptop sellers or laptop retailers, because all you're doing is identifying the genus of the particular services. On the other end of the spectrum, you have the completely fanciful marks that are just made up. Kodak, for example, not a real word, didn't exist before the camera company started using it, but it now has come to identify that particular source.
Right.
The next step down that scale of distinctiveness, that spectrum of distinctiveness, would be what's known as arbitrary marks. They're words that exist, but they have no relation to the particular products. A good example is Apple. That word has existed, obviously, but it has nothing to do with a computer manufacturer.
Right.
So those are really strong marks as well. You slide further down that scale, and that's where you start getting into the descriptive marks and the suggestive marks. And suggestive is something that just kind of conjures up a particular idea and a particular notion, as opposed to merely descriptive, which simply do nothing other than describe a particular mark. And that's really where a lot of the litigation, the case law lies with respect to the suggestive marks and merely descriptive marks. But like I said, it's the reason why this spectrum of distinctiveness even exists is because it's something where trademarks serve this consumer protection function, and the case law has developed where they have said that if something is so weak that it does nothing other than identify the genus of these particular goods or services, we're not going to allow it to have any trademark protection whatsoever.
So like the first thing that came to my head when you said too generic would be like bran flakes or something like that.
Right.
It's become such a normal term that you would almost have to have something more, because you walk down the aisle and there's 5 different brands of bran flakes, you know.
Right. Yep, exactly. That would be, I mean, if you're identifying just the genus of the goods or services, then that's something that is generic. And that's something where you can't have protection. Like you said, bran flakes. There are, any number of cereal manufacturers that make bran flakes. So that's the reason why you can't have trademark protection in it. And kind of tying it back a little bit to policing of the mark, I mean, that's something where it's essential that you police the mark and make sure that your mark is being used properly. And when I say police, I don't mean just simply look out for the way that others might be using the mark or others that might be infringing, but make sure that your mark is being used properly as well. Because if the mark is well known enough, and if people, in some ways, if the mark is too good, then you run the risk potentially of the mark becoming generic. Genericide is what it's known as.
So let's talk about that for a second.
Okay.
Right. And I'll bring up one for the geeks and all of us that hits home to me. App Store.
Right.
And I mean, and that's been in the news in the last year or two because, Apple wants to be the only one who can call it the App Store.
Right.
And I know for a fact that Microsoft and Android, Google, have kind of, and Kindle for that matter, or Amazon,
yep,
have, some of them have had to go through some percolations to try and come up with a clever way to still call themselves an app store.
Right.
Without getting sued. Is that a trademark thing, or is that something else?
It's absolutely a trademark.
Okay.
thing. That's exactly what it is. And frankly, I think that Apple is on very thin ice with that one. I think that they are in extreme danger of that being something that is deemed to be generic.
I see it that way. I mean, that is what all these other things are, no matter what they call them.
Right. Yeah. I mean, you are using simply 2 words, both being generic, and you're combining them, and you don't get any greater protection by combining 2 generic words. I mean, you kind of take it out of the App Store and the Apple context, but if you put it into a car salesman or a car dealership, you cannot have 2 generic words, car and dealership, combine them and have it identify source somehow. They're still generic. It's a car dealership. Same thing applies here. You are a store that is selling apps. It's an app store. So I think that Apple is really on very thin ice on that one. And now,
if they changed it to Apple Store, then they could get away with it because it's their brand name with store. Because I think, like for Google, they changed it to the Google Marketplace.
Right. Yep, exactly. And I guarantee, I haven't looked up the registration, but if they do have federal protection for it, the trademark office, the examining attorney that took care of that, required them to disclaim the generic portion of the mark, which is marketplace.
Right.
And all that simply means is that when you disclaim something, you are not claiming exclusive right to use that particular portion of the mark apart from the mark as a whole. So, really what you're saying is that by virtue of the fact that you're using Google Marketplace, you are not going to prevent somebody else from using the word marketplace in their.
So when I say that I have the Foster gallery, Foster is the part I'm trademarking, really.
Right.
I mean, the whole thing is the name, but the Foster part is the identifier.
Right, although you go down another area there where another restriction on trademark law is that it cannot be primarily merely a surname.
Really?
Really. Now, that's not to say that you can't get protection in it, because I referred a few minutes ago to, with descriptive marks, potentially establishing what's known as acquired distinctiveness, or really, I think a better way to look at it, a way that it's been referred to in a couple of different cases, is acquired recognition. So what that means is that even with a descriptive mark, if eventually your mark is something where people identify it as being a particular source of goods or services, despite the fact that it's descriptive, you could still get protection in it. A good example would be like American Airlines. It's a brand name, it's a trademark, it's protected, and it's probably, I suspect, because of the fact that they were able to establish distinctiveness in that mark.
Yeah.
So with the Foster Gallery, same analysis would apply. although I guess you could probably start to ask the question, is Foster even primarily merely a surname? Foster has other
Possible
other
meanings, yeah.
meanings as well, right? Exactly. So that's kind of that might be a little bit of a different analysis. Maybe a better example there would be like, for example, the Hill Gallery. If your last name happened to be Hill,
Yeah.
well, that's got plenty of other meaning.
Right.
Hill is a very common word, so it's not primarily merely a surname. But for you, for the Foster Gallery as the example, that would be one potential avenue of still getting protection. You could have a merely descriptive mark or something that is primarily merely a surname and still have that eventually acquire recognition and allow protection to inure to that by simply using the mark in commerce for so long that everybody recognizes it as
Right.
a source of your services.
So let me ask you something on that. So let's say we'll pick on the Foster Gallery. So I have it, and I've had it for, whatever, 2 years.
Yep.
And then another Foster Gallery opens up in New York City.
Okay.
And I never, I didn't pursue them to protect my trademark. Let's say that that's the case.
Right.
So we are coexisting geographically differently, all this other stuff.
Yep.
But they become very famous, let's say. Or I become very famous. One of the two.
Right.
And they become known for providing that service.
Right.
Does the more popular business have more of you're saying the surname will work if it becomes identified with what you're doing as your model, let's say, or your business.
Right. Yep.
Does that mean if you had two that did it equally and one became more powerful, does that powerful one really kind of have the leg to stand on?
Well, really, in some ways it does, and it's because what you're looking at is who is the source that the public is associating with that particular mark. Now, it's really not quite that simple because what it also comes down to is the fact that if you are using the mark in commerce and you don't have a federal registration, I think part of your hypothetical was that you were using the mark, but you didn't do anything to protect it right off the bat, and you started using it for 2 years, and then somebody else came in and also started using the identical mark. You get protection at common law, is what it's known as. And when you see a TM or an SM used after a mark, I mean, essentially what they're saying there is that they are claiming common law rights in that particular mark. Those rights are very limited in scope. They're limited to simply where you are using that mark, the geographic area that you're using the mark. And that is one of the key benefits of federal trademark registration, is that if you had, in your example, decided to actually file for federal protection of that mark, you would get rights to that mark nationwide. And everybody nationwide would essentially be put on notice that you are the exclusive owner of that. And it would be something where they would be deemed to know that you actually own that mark. So it's a significant benefit when it comes to why you would want to file trademark registration or a trademark registration with the Patent and Trademark Office. It's something that puts the entire country on notice nationwide that Matt Foster is the owner of the Foster Gallery, and you cannot have somebody crop up in New York or Idaho or California and start using it after you and say, well, I just didn't realize that you were using it because you're all the way in Massachusetts. Doesn't matter. Doesn't make a difference. And
so when you say that they use, so I see the TM on things all the time.
Right.
That's a common law use of trademark? I always thought when I saw TM, that means that they went through the process to actually register it and stuff. Is it the opposite?
No, well, to some extent, yes. And what it is that a lot of times you'll have common law registration just simply by common law rights by virtue of the fact that you are using the mark in commerce. And then you go through the process of actually filing the trademark application, and it matures to a registration, and you then therefore have federal protection as well. So you really have protection at two different levels. And what you are going to be seeing is a lot of companies will put the TM and the federal registration mark, the R in the circle. And the reason that they'll do that is it really does kind of show that they've got rights to the mark in both ways. They've got it protected at the federal level, but they're claiming rights to that at common law, and they were, established, or they may have established those even before the federal registration matured. So you'll see the same mark oftentimes designated by both the TM and the R in the circle, just at different points and at different times.
Okay, but once you get the R in the circle, that trumps the TM.
It does, right? It does,
Yeah, okay.
and that's certainly the stronger of the two. But like I said, a lot of companies will use both just to kind of maintain that, hey, not only do we have a federal registration for this, but we also have common law rights as well.
Right. Okay, that's cool. What else? Is there anything else about trade? I mean, so the takeaways that I'm hearing for the casual interest is that trademarking is really meant for business. It's not meant for you just to protect a drawing that you happen to make.
Right.
It's really meant for a product or service that you're actually intending to go out and rule the world with at some point.
Right.
And then also that once you apply for it, once you have it, it's something that you have to watch out for as far as making sure that you're protecting yourself.
Right. Yep, that's true. Yep, very true. Very true. I think that pretty much hits a lot of it, or at least in very simple terms, identifies what it is that a trademark does and how you're going to benefit by it and who would want to actually go out and seek protection for it. I mean, really, another way to look at it, too, is if you're a business owner, it is kind of critical to protect your mark because it identifies you in the marketplace. It's really the embodiment of your company and the goodwill that you have built up in your mark.
Right.
There are plenty of times when somebody has kind of gone the wrong route. They have started using the mark. They have not protected it. Somebody else later comes in and they may have been using it, in a geographically dispersed location, and then you were trying to expand into that location, and you can't do it. You're stuck
Right.
because you did not you didn't take care of the mark the way that you should have from the get-go, or potentially even worse, it could be something where you don't realize because you have not sought registration for this or done anything to protect it. You don't realize that you might be infringing somebody's mark because nobody's done a clearance search for you. And you go out and you kind of get all of this merchandise with your mark on it, or you build up all of this goodwill with your associated with your brand and your mark. And then you're told afterwards that you can't use the mark in commerce anymore. And not only that, but you have to destroy everything that has that trademark on it.
Oh, really?
So you just lost all of the money that you plugged into all of those products and all of the goodwill that you've built up with it, and you're unfortunately out of luck. I mean, for a small business, it could be
Crushing.
critical. Yeah, absolutely.
No kidding. So they'll make you destroy your stuff.
Yep. There are plenty of cases where somebody has been deemed to infringe somebody else's trademark, and not only do they have to stop using the mark, but they actually have to destroy whatever products that they have or turn over whatever products that they have so that it's not a continued infringement, so that they don't continue to sell that and put those infringing products into the marketplace.
Well, I think that this it's drumming up all kinds of stuff that we're not going to have time for today, but for future episodes. All I can think of is, like, when you say ruining someone's good name, all I can think of is all these knockoff businesses that get away with it, like in the one that I happen to be thinking of because I saw it the other day on the web was the one in China that was trying to be like an Apple store, and it was a pear instead of an apple,
Right. Exactly. And as far as federal registration is concerned, and under federal trademark law, there is something known as the Antidilution Law, and that would be exactly the type of situation that you're talking about. You're diluting somebody's trademark, and if it's a famous mark, then you can certainly invoke that and try to prevent that particular situation from happening. Another situation where it comes up a lot is with these infringing knockoff goods that come in, cheap Rolex watches or
Right.
Coach purses or whatever the case might be. If you have a federal registration, you can actually get the Customs and Border Patrol to be on the lookout for those infringing knockoff goods and prevent them from ever coming into the marketplace.
No kidding.
So just a couple other benefits that you could potentially get from having a trademark protection.
Well, I guess another, and again, we're running short on time here now, but a interesting talking point for a future show would be when we say federal laws and stuff, we're talking about just America.
Yes.
So I'm assuming there is some other fashion of what we would have to discuss when we talk about selling this overseas.
Oh, absolutely.
And crossing borders and all that stuff.
Absolutely. I mean, you're right. It certainly warrants a whole other discussion, but I can tell you that just recently I read a snippet of a case. I didn't actually read the case yet, but apparently Apple was denied the ability to use iPhone in Mexico because somebody else in Mexico already had that and was using it.
Oh, really?
In fact, I know Apple, again, kind of going back to them a second time, they did not have rights to use iPad in China, I believe it was, and they had to pay out, for them it was a drop in the bucket, but something like $50,000 or some nominal amount for them to be able to use the mark. So you're right. It's something where it is a federal law and it's limited strictly to the United States. So that's the another analysis, I guess, is that you have to go down that road and figure out where you're going to be doing business and is there some way to protect it overseas as well.
And similar to our discussion about copyright, I'm assuming in the trademark circles too, you would simply get into a situation where you're licensing the trademark or you're cooperating with the other company.
Right.
Or in Apple's case, they'd probably just buy the company.
Yeah, exactly. Right. Exactly. I think they can settle that and not be worried about it. But no, that's exactly right. I mean, a trademark is intellectual property. It's property in the same way that real property is property. So you can do whatever you want to do with that. You can license it to somebody. You can assign it to somebody. Whatever you want to do. So that's exactly the right way to look at it.
Nice. Okay. Well, great. This is fantastic. This was a great overview of trademarks. I mean, that's and it's like I said before, it's drumming up more and more questions for the future. But
I believe it.
I mean, these are what I love about these conversations so far is that they kind of open up the rabbit hole. Like there's more things that I know we can talk about, but we just don't have the time to do it all at once.
Yep. No, absolutely. I think that you're right on point on that one. It definitely warrants further discussion.
So okay, great. Well, thank you, Rich, very much.
Okay.
And next time we'll be talking about patents.
All right.
You got someone in the room with you, don't you?
You get
Is that the Rich Alves teleprompter in the room?
Yeah.
This
is get that last part out.
This is part of doing it over Skype. This is part of the charm. We say right on our site that we do these over Skype for the convenience to be able to do it in our houses. So, we had it one time where Dennis literally had his son run up and was like in the camera with him. You know what I mean?
That's what I just cut off. I just cut that off.
You just kept it from happening. All right. Well, that's cool. Well, thank you, Rich.
Okay. All right. Thanks,
great.
Matt.
Thanks a lot.
Okay. Bye.